Hello and welcome to episode 3 of the GLG Legal Property Seminars on commercial contracts. In previous episodes I've dealt with the standard REIQ contracts dealing with residential property. In this part of the seminar I propose to deal in more detail with the commercial strata title contracts and commercial land and building contracts. Once again, these contracts have provision for the finance and building and pest. Finance is occasionally completed and is no different from the residential contract. My recommendation is that it be fully completed and that the buyer be forced to insert the amount of finance that they need so the seller can make a realistic assessment of whether or not they're likely to get the finance they are seeking. In most commercial contracts there's a due diligence clause. This subsumes the need for the building and pest clause. They will of course conduct the building and pest inspection. With commercial properties these inspections go a lot further than that, so you'll often find that with a commercial property there will be a town planner involved doing town planning inquiries, council building and records inquiries, council approvals, development approvals, standard town planning search. There'll also be engineering certificates required with respect to things like air conditioning, electrical switchboards, to concrete, the structure and so forth. These are much more important in commercial buildings and the detail in due diligence is quite substantial. If you find yourself looking at or buying a commercial property, please come to us early so we can help you with the list of due diligence inquiries that a prudent buyer should undertake. Frequently buyers think they can simply get a free option by putting in a due diligence clause or a finance clause, giving them 30 days, and if they don't like it they can pull out. I won't let my seller clients go into such arrangements if I can avoid it. I normally recommend that at least $10,000 of the deposit be non-refundable to reimburse the seller for the expenses in getting the contract prepared, entering into the contract, talking to their bank, talking to the agent and various other people. Up until recently, the inclusion of a non-refundable deposit was feared to be an instalment contract in Queensland. There was a case last year which clarified that that is not the case, so we no longer need to worry about that for those of you that are concerned by that point. Now, the first notable difference between the residential contract and the commercial contract, as I mentioned previously, is a whole page dedicated to the treatment of GST. This is a very important aspect of the transaction and one that needs attention from the outset. As a general rule, goods and services tax will be applicable on the sale of commercial property. The price that you see where the property is advertised in the paper or wherever else will almost always be GST exclusive. So if the sale price is $1 million, the great likelihood is that you'll have to pay $1,100,000 to buy it if the vendor's going to give you a tax invoice. Now the reality is that most buyers don't like that situation because it means A, they've got to find an extra $100,000 to pay a settlement. B, they've got to pay stamp duty on that $100,000 at the top marginal rate of 5%, which means they're $5,000 out of pocket. In order to accommodate this, almost always will the parties try to find a way to use the going concern exemption. Now the tax office recognise that being a landlord is carrying on an enterprise for the purpose of GST. So if you're continuing to be a landlord, then you are conducting a going concern. And if you sell that going concern to someone else, they are taking over a going concern and there is no difficulty in using the going concern exemption. That is the one that's most popular, certainly the one that I prefer as a lawyer because it makes our job a bit easier and it's less complicated for the buyer and the seller. There's no need for a tax invoice. We simply tick GST 1, the property is a going concern. However, if I'm advising the seller, I need to be careful of my seller's responsibilities. Prima facie, the seller has a duty to remit GST to the tax office. So if he sells the property for $1 million, the tax commissioner will put his hand out in a year's time and say, where's my $90,000? In fact, he'll do it at the end of next month. And it's up to the seller to satisfy the tax commissioner that he does not have to pay it because of one of the exemptions that apply. So it's all very well for the buyer to say, let's use the going concern, but the seller is the one who needs to be satisfied that the going concern can be used. In order to do that, we need to have a sitting tenant. A monthly tenancy is probably sufficient. Often we'll find that even if the property might have been to be sold as vacant possession, that there is a sitting tenant or a monthly tenant that's there who can be encouraged to stay on until the date of settlement. If those circumstances don't apply, then we're often involved in preparing short-term leases for an associate of the buyer or the seller who's going to lease the property eventually, and get that implemented sooner rather than later to justify the going concern exemption. On that issue, just bear in mind that the buyer cannot be the party taking the lease. The buyer cannot buy a property that's leased to themselves and claim the going concern exemption. And if you allow this to happen when acting for the seller, you've really compromised their ability and their position with respect to GST, so be careful about that. Another option is the margin scheme. The margin scheme is very important to property developers. It's generally not that important to investors who are buying property to hold for investment. But the margin scheme is important, and I say this because where a property developer is selling residential real estate, so they spend $1 million to buy a block of land, they subdivide it into 10 blocks and they sell them, hopefully at a profit, for $200,000 each. I said before that residential real estate usually excludes GST, but in that case, because the developer is carrying on the enterprise of developing land, he is subject to GST, and every one of those blocks will attract GST. So of the $20,000 he receives, he'll have to remit 1/11th to the tax office, that is $18,000. However, if he can use the margin scheme, he only remits GST on the profit. So having paid $1 million to buy the land, he's now selling it for a total of $2 million, so he's only making a profit of $100,000 per block and must only pay $9,000 GST on each one. An immensely preferable outcome for our developer clients. So with respect to the sale, it's important, but it's also important with respect to the purchase. So if you're thinking of developing land and you're looking at buying it, how you buy it is very important as to whether or not you can use the margin scheme when you come to sell it. So please consult us before you enter into a contract for the purchase of land that you intend to subdivide, so we can ensure that the margin scheme is available to you at the end of the process. It's too late to think about it after the event if you've purchased the land in a manner that doesn't allow the margin scheme to be adopted at the end of the process. Now, that's enough for GST. The other thing I'll mention is that it's not uncommon to have GST where we just have to have GST. And so for a sale on $1 million, the seller will issue a tax invoice to the buyer for $1,100,000. The buyer will pay it. The seller will remit the $100,000 to the tax office and the buyer will claim it back from the tax office. A pointless exercise, I know, but that's what we have to go through. The only beneficiary of that is the stamps office because they get stamp duty on the extra $100,000. Many people object to a tax on a tax, but that's where we are, and that's what has to happen. If in those circumstances, box number 3 is the one to tick, GST inclusive or exclusive of the purchase price, and you mark yes or no, depending on the circumstances. Just one other thing, there are other examples of GST. There's an exemption for farming enterprises. There are some circumstances where GST simply can't apply or won't apply. The seller may not be registered for GST. It's not uncommon for us to have to craft special conditions to deal with these various circumstances. Because this is a commercial contract, it's often the case that there is a income producing activity, i.e. a lease, and there is a lease schedule. That should be completed with great care. Again, there is a potential for errors or misdescriptions, compensation, misleading and deceptive conduct claims if you don't pay attention there. As a general rule, the details about the lease will be the primary determining factor in the value of the property. The property is purchased on a yield by reference to the income, and if there's an error in the description of that, then it can be very substantial. So please pay attention to that. Again, on the topic of unconditional contracts, I acted for a client who came to me after an auction was held and the buyer on his unconditional commercial contract exited the contract under the clause dealing with leases. Now, the leasing clause in the commercial contract states that within 7 days of the contract, the seller must give to the buyer copies of all of the leases. And basically, if the buyer doesn't like them, the buyer can give notice terminating the contract. So even though this was meant to be an unconditional contract arising from option, that's exactly what the buyer did. The seller lost his contract and was never able to resell the property at anything like that value. A salient lesson there that the standard conditions need to be varied. And again, Most of the time we will give the leases to the buyers before we go to contract. We will vary the clause to say that the buyers have the leases and have read them and are satisfied with them, and they waive the requirement to delivery and they waive the requirement to terminate the contract. That's another step towards making your contract unconditional. I've spoken about due diligence clauses. As I mentioned, many buyers use them as a free option to purchase the property, which in my view is unsatisfactory. If I'm acting for a seller, I'll try to minimise that by insisting on some non-refundable component, or insisting that they sign an option to purchase agreement with a non-refundable option fee, which is the more correct way to describe what they're actually seeking. Buyers, of course, will resist that. It's a question of the negotiating position of the parties. Once again, if the buyer is a company, which is much more common in commercial, both strata title and real estate contracts, make sure there are directors' guarantees. Even though you might cover the financial risk by taking a larger deposit, the risk of litigation is enormous, and if the buyer is a $2 company, nobody wants to be in litigation with a $2 company. You simply can't win. So make sure there's directors' guarantees, so there's some skin in the game by the directors of the buyer. It's also prudent, of course, to do a company search and bankruptcy search, court searches and so forth on the buyer and the directors to make sure they haven't fleeced other people recently by similar circumstances. I mentioned before that due diligence clauses are common in these commercial contracts, and I like to include a provision that once the buyer has confirmed due diligence, the buyer cannot then seek compensation or termination, which the standard conditions may allow, for any matter or thing which the buyer is aware of or should have been aware of at conclusion of that due diligence. That's particularly aimed at something where the buyer is aware of a material defect, which might give them a right to compensation under the standard conditions, so they elect to proceed, and hence our vendor client gets slugged with a compensation claim, even though the buyer was fully aware of it before they confirmed due diligence. Those are circumstances that we'd like to avoid if possible. I mentioned before there should be a replacement land tax clause. Land tax is a very substantial impost these days in the tens of thousands of dollars, and the proper clause will recover many thousands of dollars for a seller. The standard clause in these contracts is simply unacceptable and must be amended. The standard commercial conditions also contain that extension provision referred to as clause 6.2 in the residential contract, so that the buyer may unilaterally extend the settlement date. And once again, they have failed to include any interest for the seller, so you should include a special condition allowing interest to the seller in those circumstances, remembering that the REIQ interest rate at the moment is 10.61%, an enormous amount, particularly on commercial contracts, which could be for, say, $5 million, which makes interest at over $500,000 per annum, or $1,500 per day. It's very worthwhile having it in. In circumstances where the seller may have some complications with respect to his title, for example, he needs to hive off a block from another block, or there is some pending boundary realignment or some other transaction to be registered, or there might be a receiver or mortgagee, it may be prudent to include a similar provision to clause 6.3 entitling the seller to unilaterally extend the settlement date by up to 60 days. This is often the case where clients are splitting blocks or where there's been some sort of commercial dispute, because there's always a risk of an unmeritorious application to the court or filing of a caveat or something which might hold us up. If we've got reasonable strong case, we can get rid of that within 14 days. The problem is if it's filed 2 or 3 days prior to settlement, it could make us in default under the contract unless we have a provision that allows us to extend. I've mentioned before that the buyer has right to terminate any time up to the date of settlement under clause 7, matters affecting the property. Again, it's prudent to change this to up to a date 30 days from the date of the contract in circumstances where we're going to have a long settlement date, and we want our seller client to sit back comfortably being sure that he's going to get his money in 90 days or 120 days or whatever the case might be. It'd be a very rude shock for him to get told a week before settlement that his contract's not proceeding, because the buyer knows now, and in fact has always known, that there's a realignment affecting the land that he didn't bother telling us about. If you do come across mortgagee sales or receivers contracts, please come and talk to us before you sign the contract. Some of these are horrendous documents. I've seen provisions where the buyer indemnifies the receiver with respect to contamination that's on the receiver's land and so on and so forth. They're just completely unrealistic. I've often seen situations where you simply cannot contract with these people. They're just too unreasonable, and you're better off not being involved with such transactions, no matter how good a deal you think it might be, because the last thing you want is to give an indemnity to a receiver or a liquidator, because they'll be gleefully claiming upon that for years to come if they can. So that concludes my brief comments on the commercial contracts and the REIQ contracts. If you haven't already done so, I'd invite you to have a look at the earlier episodes. Episode 1 about unconditional contracts, Episode 2 what you should look out for in contracts and special conditions to be included in residential contracts. Thank you for taking the time to view this. I remind you that this is not legal advice, this is simply commentary, and we do invite you to contact GLG Legal for any of your property needs. Thank you.